Hello, my name is Van Smith, managing partner here at Smith Strong, and today I'd like to talk to you about separation in Virginia, a big Supreme Court case law update in our family law space here at Smith Strong. And so when the Supreme Court speaks, we listen. And so the Supreme Court in 2025 has updated the case law guidance for separation and your divorce. And so let's break this down and understand it. First off, you may or may not be aware that separation in Virginia without minor children is 6 months, with minor children is 1 year of separation before a divorce can be granted. Now, before you say, okay, I won't speak to a lawyer until 6 months or until 12 months, big mistake. You should be speaking to a lawyer before the separation period begins. Certainly at the beginning, but I believe it would be best to speak with an attorney, particularly here at Smith Strong, for us to pre-plan that separation, if at all possible. But let's break down what the Supreme Court went through in its recent case law update, Lisanne v. Lisanne, a case in the Supreme Court of this year. Basically, what it said was this: Court of Appeals, you got it wrong. And what did they get wrong? The Court of Appeals took a matter up for review on appeal from the Circuit Court, where a husband was objecting to a separation period that had started in 2014. And after the parties separated, in that moment, with the intention to be permanent and separate and begin a process of statutory waiting period to get a divorce, in the interim, a few years went by. And during those years, some might say reconciled. That might be putting it too strongly. They traveled together. They spent the night, the facts showed in the case, in the same bed. They traveled with their children. They vacationed together. They had meals together. They behaved as the Supreme Court characterized as a family unit. And I think the biggest factual, although I can't say for certain, but I think the biggest factual issue here was they were vacationing, having overnights in the same bed, in the same domicile, under the same roof, after their quote-unquote separation period began. And it used to be in the trenches, family law attorneys may say, look, as long as you both mutually agree to a separation date and both parties agree to that separation date for the 6 or 12-month period, then we're probably going to be okay. Now, we're not talking to fraudulently just pick any old date, but a date where you both have the intentionality to separate, you wait 6 or 12 months, depending on whether you have minor children or not, and we're on our way for a separation in Virginia in anticipation for a divorce. As, by the way, a last resort, particularly if you have children, we want to make sure these statutory periods of delay are designed to make sure the parties have thought this through. And if cooler heads can prevail, and there is reconciliation possible, that they are afforded that opportunity before the gavel comes down and a decree of divorce is entered. So these statutory periods have a good basis, and it is good to give people a chance to breathe, separate, make sure this is what they want, particularly if there are children involved, and then proceed with the divorce if they have maintained this decision for that year or for that 6 months. So there's good reason for this. So what the Supreme Court said was, look, Court of Appeals, you said when they separated, they had permanent intent, and then as long as when they began the separation period, they had every reason to stay separated. Oh, well, whatever happened in this middle part of that period, hey, they spent the night together, they shared the same bed, they were under the same roof. Whatever occurred, we're just going to ignore all that as long as when they began the separation period, they had every intention of it being permanent and separate. And the Supreme Court said, no, no, no. The separation period must be an unbroken chain of 6 or 12 months in Virginia, meaning there can be no contravening facts. Once the legitimate period of separation begins, there can be no facts that would then suggest that there was a broken link in that chain of separation. So if separation in Virginia is defined as living separate and apart, and now you are back in the same bed, sharing that bed, vacationing together, and in a relationship analogous to marriage, that breaks the link in the chain of separation in Virginia, according to the Supreme Court in Lisan v. Lisan. And so, big update. Here's the takeaway. Family law in Virginia is very fact specific. And so please take what I've said as a reason to speak with an attorney here at Smith Strong or your own counsel if you already have them about separation. Don't just assume, because we both agree, who cares about the facts in the middle? The facts have to support that period of separation in Virginia. I hope this helps. Lisan v. Lisan was a major case law update. And in my opinion, I think the Supreme Court, for what it's worth, got it right. I think that the court, I could understand where the Court of Appeals was coming from, but I think the Supreme Court ultimately interpreted the law properly, and I think we're back on track for separation periods in Virginia after that case. Thank you.